subject, and we did get a number of questions. And I am going to weave in the answers throughout the presentation, so I may not say this is a question from so-and-so or this is a question we got, because some of them were on the same topic. If I miss it or don't answer it the way you want me to, if you're listening, I apologize. Email me, give me a call. I'd be happy to talk to you about any questions you might have from today's webinar. Please feel free to contact me. And I'm sure, Richard, you feel the same if you make any comments that people want to follow up on.
Yes, definitely. We will have a last slide at the end. Pretty close to the end, we'll be able to give the CLE information, and we'll also have a slide up that'll have your contact information and my contact information, so everybody can send us any questions and follow up. I see that it's noon, so we will go ahead and get started. I want to let everybody know in advance of proceeding through the materials today that if you're on the webinar on your computer, you're going to see probably a control panel in your upper right section. Everybody is muted. There is a chat feature in there, and you can minimize that menu of functionality. If it's in your way, you'll see a red or orange arrow pointing to the right side of your screen. Go ahead and click that. That should minimize that area so that you can see the slides clearly. Also, throughout, as I was saying a few moments ago, this presentation, we're going to have a few poll questions. Everybody who is attending on their computers will have a chance to vote in the poll. And we will make sure that we give you a little bit of time to answer and then share the results. And the people who are calling in will be able to hear those results and those questions. Unfortunately, we don't have a way for you all to vote in those. So again, welcome. My name is Richard Lord. I'm joined today by Kim Sands. Kim, you want to say hello?
Yeah. Hi, Richard. Hi, everybody.
Today our presentation is entitled Finding and Maintaining Leverage in Mediation. We appreciate everybody who is with us right now and everybody who has given us some feedback by way of questions in the development of this presentation. This is another one of our resources that we hope you find of value. This will be archived on our website, and we do really want to thank the University of Florida Levin College of Law Institute for Dispute Resolution, who is a co-sponsor along with us, Upchurch, Watson, White, and Max, in presenting today's webinar entitled, again, Finding and Maintaining Leverage in Mediation. A little bit about Kim and Richard. You can see it on our slides. There is our contact information there. If you want to write it down now, it's ksands@uww-adr.com or rlord@uww-adr.com. So our program is focusing on finding and maintaining leverage in mediation. Kim, would you like to get us started?
Sure. Just a preface to this, I have done this program for certain groups in which I present hypotheticals geared towards the subject matter or the interest of the particular group. This is a general presentation. And I want to say that when I do a hypothetical, it genuinely is a hypothetical. It may sound familiar, but it's, I don't mind from my mediations. Those are completely confidential. And as a result, sometimes my hypotheticals sound a little outrageous, but they're for analogy purposes to get the point across. So if anything sounds familiar out there, it's not to reflect any real person. It's all fictional. We should get one of those banners that they have on docudramas. These definitions of what leverage is. One of my reasons why I developed this presentation was because leverage is very important in any negotiation. It's the heartbeat of negotiation, and yet I don't always see it being used as obviously or as effectively as it can be under certain circumstances. It applies to every type of negotiation, and these definitions are common in the industry. They're known nomenclature for negotiations. You have three basic types of leverage. And leverage, of course, the definition of leverage is the ability to influence the other side closer to your position. So it's how the other side perceives the dispute. and what is positive to their outcome, what is negative with respect to outcome, and what their normative or their norms and standards are that they have that influence their decision making. So when we talk about positive leverage, we're talking about something our opponent wants. And so it depends. If you're the plaintiff, you may want money, or the defendant to do something or not do something. And that's just a broad definition of what you want. True leverage is getting down into the nitty-gritty of that. Negative leverage, of course, is taking something away, and the obvious example of that is litigation costs money, and that's usually a negative leverage factor for both sides. But that can also vary based upon who's paying and how much are they paying, and are they paying in different ways, meaning is there insurance that covers this, or is there insurance that covers part of this, and so it's easy to say we all have costs, we all have expense when we are in litigation. If you get down to the nitty-gritty of it, you have the ability now to know what the negative leverage is, what the negative influences are. And we'll talk a little bit more about that in some more detail as we go on. And then, as I said, normative leverage is if you understand what the norms and standards are of your adversary, what is important to them, what milieu they function in, then you have a better chance of targeting what's in their positive or negative interest. And that's the goal of leverage, either through direct negotiations or through mediation. And we're going to talk about that towards the end of the presentation, how effective mediation can be in mining leverage in a negotiation.
So it sounds like it's really the ability to influence what people do, how they perceive things, the decisions they make, and it really can come from what you do and what you provide and what you ask in a mediation, if I'm understanding correctly.
Absolutely. And sometimes, and I know you've had this happen, you'll have a party say to you, for example, and again I paraphrase and generalize, I don't care what the other side wants, this is what I want. This is what I need, this is my interest. That's great. But unless you give me a fact or a number for negotiation purposes that is meaningful to the other side, you have done nothing in terms of positive, negative, or normative leverage to move the other side closer to your position. So when a mediator in a mediation says, talk to me about your case, talk to me about what you want, talk to me about the numbers, talk to me about your strategy, they're looking for ways to move the other side. And so you should think of that in the cooperative nature of the relationship rather than a combative nature of the relationship. If you want to move on to the next slide, we'll go right through these. Okay, these are the common sources of leverage. And when I say common sources, what are you looking for? Well, you're looking to know something about your opponent and what their interests are. If it's a business entity making a business decision, well, you kind of want to know what their business is and where they might be going in the future and what might be important to them. It may be important to them not to settle a case. It may be vitally important to them to settle it for as much as they possibly can settle it for. It's that type of thing. It's also knowledge about your client, knowing what your client's needs are, because when you know what your client needs are, you're able to direct the negotiations towards what I call common ground, which is if you know what your client's needs are and you're gearing the case in that direction, you're looking for the common ground that the other side might have for very different reasons to get to what your client's basic needs are. It's your knowledge about your case. I think for most of the mediations we're probably talking about here, where it's a classic defendant-plaintiff dispute that's going to be turned over to another decision maker if it's not resolved here, the greatest leverage that anybody has is the merits of their case. We are all professionals. There is probably, in most mediations, a reasonable, credible high and a reasonable, credible low, and lots of possibilities in between. And leverage is the energy that gets you between those two highs and lows. And those highs and lows are based upon the merits of the case. What was a true, reasonable, credible high, reasonable, credible low on a case evaluation. And it's my feeling that the person who has the most knowledge of their case for a number of reasons and has the most reasonable evaluation of their case already puts themselves in the best position for leverage.
It does seem like this slide has as an overarching theme, the preparation that you do in advance and the collaboration that you do during the mediation itself, whether it's with your client or the other side or the mediator. And we've certainly had plenty of webinars and seminars that deal just with the subject of preparation, so that we can go on and on.
Absolutely. If you wanted to classify this series of slides, it would probably be preparation. It would, what do I do in advance of negotiation? That would be how you would, what you would also call it. The AKA common sources of leverage, what do I do in advance of negotiations? You want to be able to convey your knowledge of your case to the other side. You want to know and project. The BATNA is again, a common mediator, common negotiation reference. It's the best alternative to a negotiated agreement. You want to know what your client's best alternative is to a negotiated agreement because that's the case evaluation. You want to know what your opponent's best alternative is to a negotiated agreement because that's their case evaluation. And again, that's where I feel like true leverage begins, but you may want to say that's where it starts as well. And then collaborating with your mediator in advance, using the expertise of your mediator as a negotiator and as a mediator, more than anything else, in order to mine for the information that's going to form the basis of your leverage, and then, of course, implementing your leverage, which we'll talk about later. I'm ready to move on unless you want to talk about any of these things, Richard. Here we go. So the first thing is, what are your adversary's concerns? What factors affect your adversary's evaluation? What are the levels of decision making and who's attending? And we got a lot of questions, and I always get a lot of questions on this question. How do I get to a decision maker? How do I make sure a decision maker is attending? If a decision maker is only attending by phone, what can I do to, how should I address that particular issue, and what can I do to effectively apply leverage under those conditions? It's difficult because the short answer is decision makers ought to be there, and Florida law has given you all of the tools necessary to ask that, to require that, and to enforce that. But that's a simple answer. We obviously live in much more complex circumstances in which entities have a right to delegate decision making to their representatives, and their representatives attend in a representative capacity, and we accept that they are there in good faith to negotiate consistent with the rules of Florida procedure, which under Florida law is somebody who has the ability to settle the case up to the maximum limits of the demand without further consultation. That's a toughie. So in an imperfect world, this is what I suggest, and that's probably what's most important. If you're asked, can somebody attend remotely, that's a great opening to start asking questions of your opponent. Talk to me about this person. Where are they in the business? What's their role? Who's above them? What's the decision-making process up there? How are you involved as counsel? Where are they going to be attending from? Are they going to be devoting their full interest to this, or are they going to be divided in some way? What kind of reassurances do I have that if I participate, or if I allow them to participate in this capacity, that it's going to be responsive? And finally, if you have doubts, you need to be aware that if you say yes, or if you go to a mediation and somebody unexpectedly is attending remotely, and you continue to participate in the mediation, then you may be waiving your rights to object to any attendance issues. So you may want to say, I'm going to reserve my rights if I'm not satisfied that this person genuinely has the capacity to settle the claim as required by Florida law, but if they do, yes, I will be gracious and do this for you and let them attend by phone. Now, I don't know whether reserving it is going to be sufficient for a judge. But it's something that you can do to impress upon your opponent that this is important to you and that you are extending a courtesy to them, so hopefully it's important to them. It also gives you an opportunity to say to them, what information do you need? What information does the decision maker need to make an informed decision? In a represented situation where you have a plaintiff's attorney and a defense attorney, hopefully there's a professional relationship there, and within that professional relationship is the knowledge that both attorneys want to do the best job they can for their client. And sometimes the best job they can for their client is conveying bad news. And so you should not assume that your opponent, no matter how adversarial they may be when they talk to you, that they're not listening to the things that you have to say and aren't willing to ask you for the things that they need to carry back to their decision maker, because they don't want to look foolish by having you spring information on them or not have provided information to their decision maker that you insist at mediation they should have provided to their decision maker. These are all things that, as Richard's noted, go into preparation. You need to think about this process before you go into it, because you can have your gun fully loaded. That's a terrible analogy, I apologize. But
that's okay.
You can have, they used to say your suitcase, your doctor's bag fully loaded with everything, every piece of leverage that you have. That could all be and should be in place before you go to mediation. Now, in an imperfect world, you don't get the information, you don't have time to get the information, whatever. In mediation, the mediator has the ability to level that playing field to some degree. Not as well as if you did this work in advance, not as well as if you had collaborated with your mediator in advance and made them aware of what your needs are and what you think the needs are of the other side. That's always beneficial. But the mediator can come in and try to rectify the absence of this preparation through their role as the mediator to facilitate that process. So that's the long answer.
Yep. And the short answer may be, the more you do in advance to get to know your audience, and the other side is certainly your audience, and the more you learn at the beginning also lets you educate your client, get your client prepped for what he or she may be encountering in the process. It's going to increase the odds of that being a successful process. And you might have a loaded toolbox, but ultimately you have to make judgments on the fly which tool you're pulling out, and all the work you do ahead of time is going to give you the information that will let you make those smart decisions in advocating for your client and advising.
And let me just add to this as well. Think outside the box. It's not just the case. It's everything. It's the business
context,
dynamics, the emotional dynamics, the financial dynamics. It's who is going to be the decision maker and why. If you have multiple decision makers, why. It's knowing all of these things in advance.
Hey, Kim, I think we have our first poll question associated with this part of the presentation. So we're going to pull up that poll question, and again, those of you who are able to see it, you'll be able to designate your answer. Those of you who can't, the question is, do you routinely speak with opposing counsel in preparation for mediation? Your choices are not complicated. They're yes or no. We'll give you a few moments to record or register your vote, indicating your routine practice. And then in a few moments we will close the voting. Hopefully everybody's able to do that relatively quickly. And then we will go ahead and share the results. And we'll do that right now.
Oh, good. Well, that's heartening. That's very
almost
heartening.
A tie.
Yeah. I think that, again, it's the short answer and the long answer. For the yeses, good luck, congratulations, that's exactly what you should be doing. For those who say no, ask yourself why. And there may
52% of you said yes, 48% of you said no.
it's really an opportunity that you shouldn't miss, because negotiation is a dance. It is a collaboration, even with your opponents. And you start that at the very beginning by the relationship that you have with counsel, or you have with whoever is your significant other, I'll say, with whom you're going to negotiate. We can move on from here if you want, Richard.
I have pressed the button and I'm hoping it's coming back to me.
Yeah, Kathy, you want to make sure that we have control of this? There we go. This is also part of knowing your opponent. And I've broken it down so that you can start thinking of it in the way I think about this. There's positive leverage in your case evaluation. Now, that can switch over to negative leverage. There can be positive leverage in who your plaintiff is. Again, that can switch over to negative. You may have some influence in the beginning about how you portray your plaintiff. Same thing with the defendant, how they are perceived and portrayed. Then you can be positive leverage or negative leverage. And then the probable outcomes. What's the best alternative to a negotiated agreement? Well, maybe the best alternative is a negotiated agreement. Typical negative leverage items are time. How does the other side, how do you react to time? If you've got a case that's going to is set for trial and is going to be on a docket in 30 days, or is on a docket for trial in 30 days, and you know the other side is not ready to try that case, well, time is on your side, and maybe that's leverage for you, and maybe you use that. Expense is an interesting item. You don't always know who's paying the bills or how they're being paid. The more you know about that, is it insurance? Is it a combination of insurance and insured? Is it a combination of insurance companies? Is it a combination of people? Is it contingent? Is it hourly? Is it a long-term relationship with the attorney or a one-shot deal? Those are things that, if you start asking yourself these questions, may very well lead to the leverage that you can use with the other side, as well as use with evaluating your own leverage, your own strengths and weaknesses with respect to negotiation. And then there's collateral damage. And I mentioned collateral damage because, again, this is thinking outside the box. There's always collateral damage in a litigation for either a business or a person. There are very few businesses or people who thrive on litigation. That's attorneys. We love it. Practically nobody else does. So there's collateral damage that can occur as a result of litigation that you can bring up and talk about. And these are the things that, in the context of mediation, a good mediator is doing for you. But in direct negotiations, or in the absence of mediation, these are things that you can consider for yourself.
Knowing, yep, I think that, knowing obviously your client, your case, the other side too, you can be mindful of, things that might go down the path of, being unknown or unintended consequences. There may be more variables in play that could increase the number of unknown or unintended consequences. When you speak of collateral damage, that is what comes to mind. And certainly there's always the possibility of someone being set on a path of creating law. And you don't know if that law will be good law or bad law, ultimately. So those are the kinds of things you need to be thinking about.
Perfect examples. Perfect.
Yep. And also the revelation of things you'd rather keep confidential, keep things private, protect trade secrets and the like. All that is very important to be thinking about when you're thinking about this positive and negative leverage. Want to go to the next?
Yes, please. Okay, great. Some of the questions centered on what do I what do I need to do to educate my adversary? I have to tell you, this is part of making sure you get to a decision maker. If you know you're dealing with remote decision makers, that that a committee determines the value of the claim, or the CEO in consultation with the COO determine what they're going to do regardless of what the attorney has told them the value of the claim, you need to ask yourself, what kind of education do I need to do remotely and at the time of mediation in order to educate my adversary. And again, this is the way I think about educating the adversary or your opponent. I think about it in strategic terms, and I think about it in evaluative terms. If you're thinking about it evaluatively, you're going to want to make sure that that they have what they need to evaluate the case. You want to find out what you can do and do it to improve your position going in. You want to emphasize your strengths and de-emphasize your weaknesses. You know, there's no reason to anticipate a defense that you know is going to come. The defense, when it comes, is the adjustment that you make. They share their leverage with you. That's a weakness of my case. I make an adjustment in negotiations, but there's no need to anticipate that advance in the negotiation process, as opposed to a trial process where you have a very different decision maker. In the negotiation process, you assume they're going to point out the things that they think are weaknesses, and there's no reason why you should give them a tell as to what you think the weight of that is and how you think about that weakness, because they may think of the weakness as not being as serious as you do, because they don't know what you know, because they value things differently. Who knows? Just shouldn't anticipate them. And again, always be thinking outside of the box. All cases are unique. What's unique about your case? What makes this case different? From your point of view, that you want to be conveyed to whoever's going to be the decision maker. And the action for evaluative purposes is to educate your adversary in the manner that we've discussed. Find out what it is that they want, what they need to know based on how they go about decision making and the merits of the dispute, and share that information with them. Now, this does not mean hiding bad information. I'm assuming there's a level playing field going in of discovery and information going back and forth, and everybody has what they need through formal process. I'm talking about in the informal process, what do you want to emphasize? Or what do you want to share that somehow they've not gleaned from their mind for information? In the strategic sense, what you want to do is not make assumptions about how the other side is weighing the information and the leverage that you're conveying. Make sure they get sufficient information to make the evaluation that you want them to make. So when I say de-emphasizing weaknesses, obviously I don't mean that you ignore them completely, but you might want to counter them, and know how the issues affect both your opponent and yourself. And the way you do that, the action you take to do that, is to communicate, as we've talked about from the beginning of this presentation. You communicate with counsel and you listen rather than talk, because they're going to tell you what the leverage is. And if you don't have conversations with them in advance, that's what the mediator is going to do. They're going to communicate with counsel, and they're going to listen to what they have to say and convey that back to you.
I do think sometimes advocates will make the mistake of only saying that their case is different, and not go to the extent of showing how their case is different. They are different things, and I do think that's something that...
good point, good point. For an example, I like my client. My client's a wonderful company or person. My client's very credible. My client's very respected in their field. So what? Who cares? What can you do to demonstrate that? The great thing about mediation is it's eyes on the decision maker, eyes on the client. Plaintiff or defendant may be a great asset. You need to convey that either by eyes on, or by saying something much more personal about them, or provide more factual detail, the type of detail that might, filter its way through a jury's imagination and hit on some universal themes that move juries and judges. And you want to be able to convey the specifics of that consistent with what your theme is of the case. That make sense, Richard?
Yes. Want us to move on to the next slide?
Yeah, let's move on.
I'm looking at the time. I think it's a good thing to do is advance to the next slide.
Okay. We've, talked about all of these things. Let me just add a few. This is kind of a going over the things we talked about before, and I don't want to read the slide to anybody. I want to jump down to the last one. Asking questions. I wish I had more time in the mediation process itself to ask questions. Sometimes you do have to make assumptions and test the assumptions in mediation. You don't have the time to ask the questions. But in preparation, you do have the time to ask questions. Now, you might not get answers. You might not get answers you want. You may not trust the answers. But it's information, and the more you talk and the more you try to mine for it, the more information that you will get. And then there's always the default to the mediator. You want to move on to the next slide for time reasons, and I think we've covered these things. There's lots of talk about the joint session. I always have people say, should we do it? In California, they don't do it. I've heard other mediators say, I don't like it because it unravels the process, and I spend the next 2 hours putting it back together again. That may be true, but by and large, the joint session is an extremely important part of a mediation, in my opinion, not only to the mediator, as it is, but to the parties. It may be your first and only opportunity to have eyes on the decision maker and influence that decision maker with your knowledge of the case, your knowledge of the client, your respect for their sensibilities and concerns, if that's what you want to convey. You can demonstrate your knowledge of your case, and you can show it. And why is that important? Because there is leverage in knowing your case and being able to try it right now. Very few people come into mediation with the idea of what's my best alternative to a negotiated agreement. It's trial, and I'm ready to go. To the extent that you demonstrate that's not the best alternative to a negotiated agreement, and you're not ready to go there, you're giving up leverage. So your presentation should demonstrate your comfort with your client, with the subject matter, and your ability and expectation that you will try that case tomorrow if necessary. And yes, I say that phrase over and over and over again because it's so important. You want to move on to the next slide so we can get through this section?
Sure, and I could not agree more that the joint session is probably, if I had to pick the one most important part up to the actual consummation of any agreement that's reached, would be the joint session by far is the most important part, and if it's done well, it is extremely important. If it's done poorly, it can be very impactful in a negative way. So when you do them well. That's your chance to listen, watch, and ask as well questions to learn more about what might motivate the other side and what might shake the other side.
Okay. You know what's leverage in your mediation? Your mediator. And I think we got a poll question with this, so why don't we go to that and then go into the subsequent presentation.
We do have a poll question here, so we're going to again show that. I'll read it to the listeners. What factors are most important to you in selecting a mediator? And the choices are cost, mediation experience, substantive law experience, reputation. The last choice is personal experience. So if those of you who have access to your computer can vote, and those of you who are in your offices or listening on your phone without access to the computer, I'll go ahead and read off the results. We'll go ahead and close that poll. And I will share the results. This will be interesting for us to know.
Well, all of these polls are interesting to me. Oh, that's
Yes,
interesting.
cost 19%, mediation experience 49%, substantive law experience 47%, reputation 42%, personal experience 40%.
Okay, once again, I'm happily surprised by that. That makes sense to me from a mediation point of view, and from the point of view of having been a litigator for 25 years and having to deal with all of those issues. So that's interesting. As I've indicated, you know, your best source of leverage, your best leverage in mediation is your mediator. I think every working day, this is what I do, mine for leverage and implement it. Now, again, we're going back to definitional terms because this is the mindset of your mediator. And so there are various types of mediations, and you've probably noticed different styles and different ways of going about mediation depending upon the range of subject matters that you handle. There's evaluative mediation where the mediator actively participates in helping the parties identify the issues and supports the party's perception of the strengths and weaknesses when they're talking with the other side. The mediator, if the mediator has, you know, experience in litigation and with the issues that are being discussed, may also offer their own observations. And mediators are good sources of observations because even if they don't practice in that substantive area of law, they may be a better source of how might a judge or a jury who also don't practice in that area of substantive law, but as an observer, a third-party neutral observer, how they might react to the issues that are being presented. Sometimes we get down in the trees and we want to pull back to the forest. And a mediator is a good source of you know, hitting those ideas off of and not having them be used against you. Transformative, facilitative and transformative mediators don't evaluate, and so evaluative mediation it differs from all other forms of mediation because the mediator is kind of an active participant in the capacity as a neutral participant. You want to move forward for me? Facilitative mediators don't evaluate the case, they don't direct the parties to a particular settlement, so they don't offer strategies or solutions. They simply facilitate the conversation. And I think most mediators that parties in litigation deal with are probably a little bit of both, of evaluative and facilitative. And so sometimes the question is, which is more needed for this particular case? Do I need to be more evaluative? Do I need to be more facilitative? Most mediators switch around in the course of a mediation, perhaps, when they figure out what is it that will best suit the circumstances. And again, this is the way in which you can prepare your mediator, you can collaborate with your mediator, and you can talk to your mediator at mediation to make sure you get that proper balance of evaluative and facilitative going back and forth.
I do think mediators with both of these modes, facilitative and evaluative, can really help. You know, you're going to be wanting perhaps that input and that collaboration with the mediator on not just, you know, the merits of the arguments or the merits of the case, claims and defenses, but also the way in which you go about mediating and how you propose what you would like to propose and when you propose things. All those things can really have an impact, and it's good to have a mediator, I think, who can, you know, go down the facilitative track and the evaluative track at the proper time.
Absolutely. Absolutely. You change back and forth sometimes, or you change from evaluative to facilitative in the course of one mediation.
And a lot of times the mediators are the ones who would pay attention to, you know, what type of, you know, mediation is being practiced, and the consumers of the mediation service being provided won't really probably pick up on the differences or even care that much about the differences as long as they see things going constructively.
And that's fine, but if you want to do it right, you understand what the mediator is doing and why they're doing it, and you help them do it. Or you get them to help you with what it is that you're trying to accomplish. And so part of the seminar, part of this section is, you know, what's going on in our heads, Richard? What are we doing? What are we? Yep. What information are we looking for? And how are we going to use it?
I know talking about what's going on in the other room oftentimes, also implicates what's going on in the mediator's head too, so it is all very important.
Correct. If every mediation was facilitative and all I had to do was, pass numbers back and forth, it'd be a real easy job. It would still be a job, but it'd be much easier. Yes, go forward a little bit. Transformative mediation is probably not anything anybody in litigation does, but I will say that I have employed these techniques in mediation before when they are necessary. You are most likely to see them in negotiation between countries that are going to war, or in negotiations that might be more apropos of our milieu of family mediations. Family businesses are where I've sometimes gone into a transformative mode. Trusts and estates. When you're dealing with people who are either going to do business together or are going to have to live together as a family going forward, there are elements that can be employed. It's obviously not usually the goal of the parties or their representatives, and so it's not always a critical part, but it is something that is a tool in the mediator's chest that they can use that can actually facilitate resolution on all levels, on the levels that everybody is concerned about.
Right.
But the hallmark of transformative mediation is we don't care whether you reach an agreement or not. We're just, trying to get you back on track to having constructive conversations. Or you can go to a therapist. That's the other thing. Next slide, please. Transformative mediation is practiced by lots of therapists. I'm losing you, Richard. Here we go. Mediation with arbitration. I mention this because we do it. It's not common. People have really strong feelings about arbitration, but I want to just mention it because it is an option, and there's things that you can do to explore this option that may make it more valuable to you than it may have been previously if you think about it in terms of how we generally think about mediation or arbitration. You have a mediation and then go straight into binding arbitration with the same professional neutral. That's fine as long as the mediator discloses and you appreciate that there's some ethical problems to that process, because if you've been through mediation with the professional neutral, you've probably shared information with them, or they have gleaned information from being with you, whether you knew you shared it or not, that we'd like to think we forget, but we don't. So if you've mediated to a bracket and you can settle a case between 500 and $1 million, and you want to turn it over into an arbitration, a binding arbitration, or even a non-binding arbitration, because that's as far as you can get, that's the functional equivalent of saying I want a silver bullet, unless you make it binding. There's also, that's okay, I can keep going. There's also the idea of arbitration does not have to be the three-person panel. Arbitration is any kind of private judging by agreement. And so you can make an agreement if you're in mediation and we've got this range and we want you to judge this, or we want to take this range and have somebody else judge this. As long as you reach agreement about the essential terms, that is it going to be binding? Is it going to, what rules of discovery, what rules of evidence are we going to apply? Can we agree upon a single neutral? You can significantly reduce the time and expense associated with a piece of litigation. And if that's what's important to your client, and it's also important to the other side, this can be, or arbitration can be, an extremely useful alternative resolution tool if you realize you control the terms. Now, you only control the terms to the extent you have an agreement to control the terms. There are certain statutes that will require this, and I've never seen people be particularly happy when they're ordered into it, but it all depends on how much thought and preparation you put into that fundamental question when you first sit down with your client, which is, what are my options with respect to resolution? Everybody should be having a conversation like that with a client at the very beginning, because there are options that are available that may turn out to be the best options for that particular case, but they're not the most common options. I think we have a poll.
I think we have a poll, and you lost me for a minute. Hopefully you have me back.
You are back. You are back.
Very good. You know, when we rely on technology, sometimes we're the victim of it. So here's the next poll question. Which form of mediation do you prefer? Evaluative, facilitative, transformative, or mediation arbitration is your last choice. Again, that's those of you on the computers, hopefully your computers cooperate and you can answer them, and we will read the results. Those of you who were watching probably saw the slides bouncing back and forth for a moment, and you all couldn't hear me. I thought I was being brilliant, but nobody could hear me. So we'll go ahead and close that poll. And the results are 57% facilitative, 35% evaluative, 4% transformative, and 4% selected the mediation arbitration option.
Well, good. You know, that's very interesting. What I would say is it would be extremely helpful if you kept that in mind when you're choosing a mediator, or when you're communicating with the mediator in advance of mediation as to what it is that you want from the mediator. Because the mediator may be the last one to know what is going to be most effective under the circumstances, because they come in cold. And mediators, I come in cold all the time into mediations, and that's fine. I'm not criticizing it. There are lots of reasons why that's necessary, but it's not ideal. You want to move on?
Yes.
So, I want to know whether it's evaluative or facilitative, or which mode I'm in, because different things are required depending upon what the case needs. We've talked about the value of the mediator and identifying and using leverage as part of the confidential process. What do I want to know? What do I need to know? I never want to know what your evaluation is. I never want to know what your numbers are, because that removes my ability to say I don't know at any point in the process. And I want to be able to say that, because as a professional neutral, I can confidentially employ leverage, and I can protect confidences, and I can advance the negotiation to a certain spot. But the worst example of this is if the defendant tells you they're willing to settle the case by paying $40,000, and the plaintiff tells you they're willing to settle the case by taking $30,000. Well, now you got a $10,000 problem, which you can either decide to take the money yourself as the mediator, or when you know that's going to happen because they've let you know that, you need to step back, and that needs to be their process. Now, that it rarely happens, because most experienced mediators are not responsible for the numbers, are not responsible for, we may strategize, but we don't evaluate the case. We may provide evaluations depending upon what room we're in. The evaluations change depending upon what issue is being brought up. The evaluations change, but we don't provide evaluations. A good mediator will not tell you this is what you should do, this is what your case is worth, because they can't know that. And a good attorney can't know that. Only the client knows that. But if anybody is in a position to advise and recommend, it is the attorney who is representing that party. It is not the mediator. You got to remember
the mediator can really focus on helping you analyze the point or evaluate an issue, things that might impact decision making in your room or the other room, or in the courtroom.
Right. We are there overall to facilitate that conversation, and sometimes that means we have to assume an evaluative hat, and while we do it, we protect confidences. So you may never know what's going on in the other room. You may never know what leverage we're bringing to bear in the other room, because we can't share that with you. We're not going to share what the positive and negative influences are for the other side if they don't want you to. But it still has an effect.
And we spent time talking about the effect, and the focus, but certainly we can help in terms of how you're having the conversation. Again, part of this conversation we're having today in this webinar is what are we conversing about, and part of it is how are we doing it. And in mediation, you're having to make choices about what you're conversing about, you're sharing, how you're reacting, and the manner in which you do it. It's not just the what, but it's the how, and we can really help on the how.
Right. So remember that mediator's responsibility are to all the parties, and how can you make that work for you, even though you don't know what's going on in the other room. You have to have trust, and this comes down to you should trust your mediator, that they are conveying your message and what other messages they realize can be exploited to utilize mediation. And it goes both ways. If the opposing party does not think that that's a two-way street, then you've lost the value of your mediator. If you undermine your mediator's ability to be facilitative or evaluative, then you've undermined the ability of a mediator to be effective when you need them with your client or when you need them with the other side. So
Correct.
You need to think about your mediator in a collaborative way. It's better to strategize with your mediator than exclude him or her. I like to put her.
Right.
Or send mixed signals, because that just may complicate the matter.
Yep. We have another poll question.
Okay, good.
And I think we need to do it now just to stay on pace.
I appreciate it, Richard. Shut me up. I can ramble on about the subject forever.
Question is, do you routinely speak and or submit a mediation statement to the mediator in advance of the mediation? Your choices are yes or no. Those of you who are just on the phone, you can't vote, but you know your answer. And we'll close that in just a bit and let you know the answer. That's probably enough time, since there's only two choices.
Yeah, I try to keep it simple.
Yep, and the answers are 82% yes, 18% no.
Okay, again, good. Good. My feeling is you submit a statement, you pick up the phone and call them, but obviously there's exceptions to every rule. This is a perfect balance. If this reflects the balance of your practice, great. So I'm again positively happy about that. Want to move on to the next slide?
We can do that.
Return to the presentation. I'm going to just continue talking.
Keep talking, and as soon as I have the ability to advance our slides, I will do that.
So continuing talking about the power of the mediation process and the confidentiality of the mediation process and the ability of the mediator to offer both facilitative and evaluative capacities. What does that give you? Well, that gives you the ability to assess in real time the application of positive, negative, and normative leverage. And it's important to remember that you may not know what exactly it is the mediator is saying and what exactly the opposing party is responding to, but it should come out in the numbers, if it's not, or in the response. If it's not coming out in the response, then whatever is being conveyed is not having an effect over there for whatever reason. Hopefully you or the mediator can find out what that is and try to have an effect on it. But it always comes down to the numbers or the demands and offers. And you can change a fact, you can add a piece of leverage, and you can change a number, or you can change a offer or demand. Those in and of themselves are communications that have leverage. So one of the ways that you might want to test whether something is meaningful to the other side is to offer options in terms of an offer or a demand and see which way they go. Or to change your demand or change your number to something that's different than what they might have anticipated or reflects something different than what you previously communicated, and then see what happens. Typically has to go with a message with the mediator that makes it apparent that that's what you're looking for. But that's how you measure the value. All of this information that you are bringing to bear and that the mediator is bringing to bear with respect to you and with respect to your opponent has any meaning. It comes out in the negotiation. We have not
Can you
moved
hear
on to
me
the next
now?
slide, so I am. I can hear you, but we've not moved on to the next slide.
Okay. I am seeing things moving around on my...
Okay, well, I'm going to go on, and then we're going to be done. So again, to put this in terms of the way I look at it, there is mediation as an event. In which, oh, good, we're back. Okay.
Yep, there it is.
Go to the next slide. I just talked about this slide. Okay, this is my last slide, I promise.
And I think we have a poll at the end of this one, too.
We do. We look at mediation as an event. You need to consider what the perils are of, when I say event, I mean, okay, we're getting everybody together, all of the decision makers, and we're going to decide, that's the day. We're going to use the power, the leverage of mediation as being an event to resolve this case. If numbers have been talked about previously and nothing has changed, people are going to want to talk about the numbers that happened previously. So the mediator is going to want to talk about what's changed. Effective joint sessions can shift because that's new information, that they can shift to the leverage because we're seeing how you perform as a representative. We're seeing how your client performs as a party. We are face-to-face with a decision maker. That can move negotiations from an event point of view. Effective joint sessions, effective private caucuses, controlling the dynamics, which means not getting too far afield of what the goal is, and effectively utilizing your mediator are all part of mediation as an event. And again, the action in that instance is you want to prepare your client for decision making. As an event, you want them to know where it is they want to be, where it is that they need to be, and what that will mean when they get there. And when you use mediation as a process, can you go back to that previous slide just for a minute, Richard? When you use mediation as a process, and by that I mean settlement is always a goal, always should be the goal of any mediation, but if it falls short for some reason because there is a lack of information, there's a negotiation tactic, such as holding or walking or something else like that. If there's multiple parties, that almost guarantees it's got to be a process. Well, I'm told Richard has lost the connection, so I'm just going to keep running right through this. If there's multiple parties in the mediation, you kind of have to work on that in advance because that's going to change the dynamic. That means if you have 5 parties, you arguably have 5 different heads. If before the process you have reduced those to 2 heads because 4 of the parties are on the same page, that's the type of preparation I'm looking for and talking about. In multi-party cases, there's the effective use of multiple mediation conferences, and again, that's a preparation issue that goes to preparing with looking at what you've got as a case, preparing with your opposing parties and advocates, and preparing with your mediator. And your mediator, again, can play the role of the facilitator, the professional neutral who makes sure that whatever needs to happen in advance of informed decision making is happening so that when we all get together, that will be a meaningful process.
And Kim, I'm back if you can hear me.
Okay. I mentioned the effective use of proposals for settlement because you can, and many people do, come into mediation with proposals for settlement, and they themselves can form the leverage within a mediation, either negatively or positively for somebody. They have meaning within the negotiation, and this is again a planning issue because if you plan out, is my proposal for settlement going to represent a reasonable, credible offer to settle so that I hope it will settle the case, and therefore I have something else to discuss at mediation, or is it going to be the low on which I base or the high on which I base further conversations? All impact what it means when you go into mediation, but we all know proposals for settlement have leverage or can have leverage in some capacity. And so when you think about it as a process, the process is preparing your adversary for decision making, meaning that you start before the mediation and you stage the mediation if necessary, if that's what's necessary based on the complexity of the issues or the multiple parties, and that's when you have a case that is unlikely to resolve with mediation as an event. And this is, again, from the mediator's point of view, how they're looking at how do we apply the leverage that we have, or the leverage that we can mine during the mediation to achieve the goals that the clients, the parties, give us. You got anything to add to that, Richard?
Very good. You know, you said the word plan a little while ago, and that makes me think of flight plans. Maybe not a very good example or analogy or comparison, but really a good pilot. Lawyers should be preparing their flight plan, and you always know that you need to fly the plan, but also be able to react and make decisions and judgments based on the variables you encounter along the way. You know, look at your mediator as another sensor, another a source of data. You know, we can't share everything, but you can ask us things that we might be able to share, and you can also look to us as something to help you interpret where things are headed and where the data is maybe leading you. So with that, I don't know if you have anything else, Kim, to say before we wrap it up. I think we're getting close to the proper time to read off our course number, and I do want to say something about an upcoming webinar that we have. But
yeah, I just want to mention again to cover a question, or if somebody has any questions resulting from this presentation, I'm available. Richard, I know you're available. You can email me a question. You can give me a call. You can before mediation. You don't have to do this through a written summary. You can pick up the phone and call them and have a conversation with them. Sometimes the best information a mediator gets from a party, the most helpful information a mediator gets from their party is that information that's given to them informally by a telephone call before mediation about what they want. And whether they need an evaluative mediator, whether they want a facilitative mediator, whether they want something in between, what they think are going to be the issues, what they think the leverage is going to be. Those are great conversations to have in advance, and you never put anything in writing. So if you want to contact me about questions from this or for any other matter, you have our contact information on the screen right now, I hope. Please feel free to contact us. Yes.
Yep, again, yep, Kim Sands at uww-adr.com, or you can email me, Richard. That's rlord at uww-adr.com. I want to thank you, Kim. I want to thank all of you who attended. Also, special thanks to the University of Florida 11 College of Law Institute for Dispute Resolution. Florida Bar course number. This has been approved for one general credit is
1609011N as in Nancy.
Those of you who are members of the Florida Bar, take time to jot that number down. Again,
1609011N as in Nancy.
Larry Watson, our partner and moderator and panel mediator, Brandon Peters, will be presenting our next webinar. It's scheduled for Thursday, May 28th, and it's going to be developing and enforcing good faith requirements for civil trial mediations. Again, that's May 28th. You can learn from Larry Watson. Brandon Peters will be moderating, and again, it's developing and enforcing good faith requirements for civil trial mediations. Thank you again, Kim, and thank all of you for listening.
Thank you, Richard.